Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 88 of the Business SOS podcast. We're very excited that we're getting closer to episode 100. If you want to reach me, you can send me an email to richsierra.com. If you have a legal question you'd like me to go over the show, I'm happy to take a look at it. If I select your question, address it at the show, I will send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. So before I start, I want to tell you a story, and we'll go into the topic of the book. So a few months ago, I received a call from a prospective client that wanted to, was offered the opportunity to run a restaurant. He did not own the restaurant, but he was going to be the manager of the restaurant through something called a management agreement. He was going to come in with his people and basically run the restaurant, and they were going to share profits in expenses, but in essence, he was going to be the de facto owner of the business. He asked me how much it is to develop a management agreement. And I said, these agreements are a bit more complicated because there are a lot of provisions in the agreement that we'll have to discuss before we actually draft it. So I gave him a quote, and, I didn't hear back from him. And then, so maybe hired another lawyer or decided to do it himself. I didn't know. So it's fine. Fast forward a few months later, then I received a call from him as well. And I said, okay, so what's going on? He said, well, I went ahead and, did a management agreement by myself, and we just got evicted. So I said, what do you mean we? Yeah, we found out that the owner of the business was not paying his rent, and the landlord evicted us from the restaurant. And I said, well, did the landlord know that you were managing this restaurant? And no. So that could be a violation of the lease as well, but we'll talk about that later. And I said, well, do you have a contract with the owner of the business? He says, yeah, we have a contract. And I said, well, let me take a look at it. And so the long story short is, in this particular case, is that this particular client relocated from California to Florida, sold his house, relocated his family here to run this business. So he appended the family to come here, and then to find out that the owner of the business, who invited him to run his restaurant, was not doing his job, was not paying the rent. And in essence, really affected him significantly. So he wants me now to enforce the contract that they had. So, which is a different conversation altogether about the provisions of that contract. We're not going to go into that today, but today my topic is going to be protecting yourself when entering into management agreements. And I'm going to talk about it today from the perspective of the individual, if you're the one who's going to be running that business, not from the owner of the business who's going to bring a manager to run that business, but from the other side. You're basically being approached to run this business. It could be a hotel, it could be a restaurant, it could be a medical practice, it could be a number of businesses that could be a gym and a fitness center, any businesses that you might be able to run and manage. You can get in a management agreement. So I want to talk about that today from that perspective. And there's some similarities between a management agreement and a joint venture agreement. Some of the provisions are kind of similar to each other, but I want to talk specifically about if you're considering a entering a management agreement, what to consider, what to look for. And the first advice that I will give you, as I have said repeatedly now, this will be the 88th episode. If you're going to go into a contract, it's better to have an attorney help you prepare the contract and advise you as to the provisions of the contract. It goes without saying. I mean, you have expertise in your field and your profession, but there are a lot of nuances in contract drafting that unless you have done it for years, you're not going to know that what to do. You do not know what you don't know. And I'm willing to bet that that contract, that it was self-made, does not have those provisions because you don't know them. You're not do this for a living like we do. So first thing is get an attorney. If you're looking to to reduce cost, and by not hiring an attorney, might be a few $1,000s, and preparing a well-written contract that will protect your interests, will protect you in the case there's a breach of the contract, will give you enforceability provisions, will establish the terms of what you agreed to do, then you have to consider whether going into that venture in the first place. Because the consequences of saving a few $1,000s in the front end can be devastating on the back end when you're going to find out that the contract perhaps that you wrote might not be enforceable, or that the contract that you wrote does not have the protections necessary for you to be able to enforce it. So you're not saving money when you're saying, I'm going to basically go down on the web and download a contract and come up with some terms, or perhaps use the other side's attorney because he's helping us both. That's not the case. If the other side, in this particular case, the business owner, has an attorney, they're not representing you. Just because they're friendly and cordial and they're going to be professional about it, they're not there to advise you about what you should include in that contract to protect you. So don't be fooled by that. If you're going to have a contract that is so important, it's better to have an attorney help you and do it the right way. So let's get into it. What is a management agreement and why does it matter? Okay. A management agreement is where you, as the manager, you're going to be running somebody else's business for compensation. There are many different ways that you can be compensated. It could be a salary. It could be a percentage of the profit. It could be a combination of both. It could be an ownership interest in the company. The good thing about drafting contracts in a business sense is you have a white canvas. You can be very creative in how to do it. So, but that's in essence what a management agreement is. Common uses for management agreements could be restaurants, hotels, retail stores, gyms, fitness centers, medical facilities, anything that is not perhaps a license. In the case of medical practice, you have a medical director. You can have a management company run that. But for the most part, most businesses can include a management agreement if it's done correctly. The contract has to be written, and the contract has to be signed by both parties. So often I receive, when I ask for, I get a lot of calls for potential clients say, somebody breached the contract. And I say, can you send me a copy of it? Everything begins with that contract. So when I ask, can I see a copy of the contract to see what we're talking about here? I get a Word document. And I'm like, great, I see what the draft of the document states, but I need the signed copy. Do you have a signed copy? No. We just acknowledge it via email. We say, looks good. All right. That is not a signed document. And it makes, yes, there are ways you can incorporate that email acceptance into the contract, but that in the context of litigation, it becomes an uphill battle to connect those dots. It's so simple now to get a signed contract via DocuSign, via Right Signature, e-sign. There's no excuse now with the technology that we have and how easy it is that if anybody's going to enter into a contract with you, for them to sign it. They cannot be too busy not to sign the contract. If they're too busy saying, no, you know what, I'm not moving, I'm not doing anything until you sign that contract. I need that signed contract, and you need to have a copy of it. I have situations that say I signed it, I don't have a copy of it. Who has it? He has it. I'm like, no. So if you enter into any type of business agreement with anyone, please, you sign it, they sign it, get a copy of the countersigned signature. So then, in the case you need to enforce it, or get advice about the contract, then we can go ahead and advise you properly. It's difficult to work with drafts of documents or Word documents that are acknowledged via email. So please, seems intuitive, but I see that often. Some of the key components of the management agreement. Again, this is not a comprehensive list, simply to give you some pointers in what to look for, what to perhaps discuss. But please understand that just what I'm telling you here is not going to be enough to draft a comprehensive management agreement. I better give you at least some ideas of what to look for, what to ask for. But at the end of the day, my advice still is that if you're going to enter into a management agreement, get an attorney to help you who understands these contracts and knows how to write them. Okay, so don't go at it by yourself. The compensation is important. It has to be clearly defined. How are you going to get paid? And before that, what are you going to do in terms of running that business? That has to be clearly defined here. And I think that goes into point number 3. But let's start with compensation. It must be clearly defined. Are you going to be getting a salary? How much? How often are you going to get paid? Who's going to approve the payroll? Are you going to be receiving any type of bonus or percentage of the profits? And how those profits are going to be calculated is very important. I see in many contracts that they say, well, you're going to get 10% of the net profit. Great. But there's no definition of net profit into the contract. So how do you define net profit as far as contract? All expenses? Or it's going to be salary? It's going to be operational expenses that are clearly defined in the contract? That's to be clearly defined. How often that's going to be paid? It's going to be quarterly, monthly, when? So that's to be defined in the contract. What expenses are going to be deducted before calculating the net profit? That's to be there. And what happens to the profits? You don't reach profits. You only get salary and not the percentage. That's to be included there. Who has access to the bank account? It's another point that is important. As you as the manager, will have the ability to be added to a signatory to the account? Will you have the ability to pay expenses? Are there certain expenses that require the owner's approval? Can you hire and fire, employees? And I think we'll go over that. But the key here is how much operational control you will have of that business. And one of them is if you have access to a checking account, you have a significant amount of operational control because you'll be able to pay expenses as well. So that's important to know. So one of the key here is that if you're going to be as part of the management agreement, that you will be added, you'll be able to pay expenses. You need to be added as signatory to the account as an authorized user of the bank account. Number 3, decision-making authority in daily operations. As the manager of this business, will you be, what type of decisions can you make independently in that business? Day-to-day operations. Are you going to be able to hire and fire staff? That's important to know as well. Are there certain decisions that you need to consult with the owner of the business? And there are a wide range of topics here to discuss, and that could be a podcast in and of itself. But for the purposes of today, it's important to know, I'm going to run your business. Can I hire and fire personnel? What limits do I have in terms of purchases? For example, if you have a restaurant, you need inventory for your business, restaurant to come in. You need food, you need supplies, you need refreshments, you need a drink, alcohol. You need to replenish that restaurant to be able to serve to your customers. So if it's customary, most likely the answer will be yes, up to a certain amount that is customary for that business to run. But say, for example, if you want to replace all the staff, that's something that probably will require the owner's approval because you're completely changing the entire nature of the business. Or if you want to go into another lease, for example, that's something that requires the business owner. We'll talk about lease agreements in a second as well. Business expenses and reimbursements. In some cases, management agreements, you end up investing your own money to the business that to become kind of a part owner of the company. That is fine, provided it's in the agreement. It's important. I cannot emphasize that enough for you here. Sometimes you have supplies that you want to bring, or some your own equipment that you want to bring. That's fine, provided that that's had agreed upon. And what happens if you decide to terminate the contract? What happens to that equipment? That has to be decided as well. Has to be discussed. Also, if you have expenses that you pay out of the business, did you pay business expenses out of your personal account? When are you going to get reimbursed for those expenses? All that has to be included as well. Let's talk about lease compliance and landlord approval. In most leases that I've seen, commercial leases, there's a provision there that says if there's any change of ownership in the company, it could be more than 10%. It could be, a change of ownership. The landlord needs to know. But there's also a provision there that includes change in management as well. So if you're going to have a management company, if you're going to be a manager, because I'm talking from the perspective of the manager going into running a business, if you're going to run this business operation, you basically can be the de facto owner of the business with the exception of selling it. You're going to basically run everything. The landlord needs to know. And the lease agreements include a provision that the change of management, the landlord needs to know and they have to approve it. The landlord has the right to know who's operating a business in his or her property. So it's important to know that for many different reasons. So if you have a situation where the owner says, you ask the question, does the landlord know that you're going to be making this arrangement with me, which I'm going to run your business? I'll be the face of your business from this point forward. And they said, well, he doesn't need to know. It's fine. They're okay. That's a red flag. My suggestion at that point is to get a copy of the lease agreement, run it by your attorney, and then look at that section. And I'm willing to bet that there's a section there that there's a change in ownership or management that has to be approved by the landlord. And there's also a good reason for that. Somebody slips and falls in the business, somebody sues the business, something that happens, you're basically running that business, the landlord has no idea who you are, okay? That's a violation of the lease. And now I'm not talking about slip and fall, I'm talking about you being there running that business without notifying the landlord. Most likely it's a violation of the lease agreement. So nothing wrong with management agreements, nothing wrong with running the business for somebody else, but the landlord needs to know. There's also some risk management issues here. Okay, and I know digressing into leases, but you need to make sure that you're included as well on that general liability policies as the one who's running that business. So you're covered as well in the case somebody sues that business, sues you. So that's the reason why it's important to have an attorney help you draft these agreements, because we will be asking those questions. And if the answer that we get is not the one that should be given to us, most likely we would advise you, give this a second thought. Because something is just not right. They're not giving you the full story. So you have to kind of know that. So in going back to my example, is that the worst case scenario actually took place here. The owner of the business did not disclose to this manager that they're having financial problems. And by doing and then not complying with the lease, the notices were not going to the manager. The notices were going to the landlord. To the owner of the business. And by not doing the due diligence, which is a different topic in itself, as a manager, you have the right to do due diligence. You have the right to know, I need to look at the finances of the company to know, are you current with your lease? You got to do the same due diligence you do as if you're going to buy into this business. And that's what we can help you with. An attorney can help you with that. But by failing to do the due diligence, by failing to ask those questions, run into a situation where the business owner was not forthright with the manager, hoping that this manager can turn things around for him because he had financial problems, promising him that he was going to give him a percentage of profits. There were never going to be any profits because the business was upside down already. So in that case, my client really got into a really bad situation. For failure to exercise due diligence, failure to get the proper agreement, failure to hire an attorney beforehand. And I'm not judging here. Everybody tries to take shortcuts, but I'm saying these things are preventable. They're preventable, and I'm seeing it happen day in and day out. There are no shortcuts for this. If you want to be a business owner, there are no shortcuts. You take shortcuts, at some time they're going to come back to bite you. And that's basically the reality. So let's talk about some of the common mistakes, which I've actually gone over that already today. Common mistakes that to avoid when entering into a management agreement. I mentioned it before, not having a written contract, and I've seen this before. We had a verbal contract. We had a verbal agreement to go into this partnership, and I'm going to run the business for him. He was going to give me a percentage of money. He didn't pay me. I wouldn't enforce it. There's no written agreement. It still happens. Not having financial controls. If you as the manager have no way of knowing what's going on in the bank account, you don't know what's happening to that money. There has to be some financial controls. So if you're going to be running that business, you should be able to have the ability to write checks as well, with some limitations, of course. There's to be outlined in the agreement. And that's the hard part. Drafting the agreement is the hard part, because it goes into a lot of details about what you can and cannot do. But also the owner has limitations as well, what he or she can and cannot do as well. In this example here, hiding financial losses. The information was not disclosed. I think it was material, should have been disclosed, and it was not, and that's where we run into a situation. Not protecting personal investments. In this case, you bring your own equipment, your own supplies, your own materials. What happened to those if the relationship terminates? So that's an important component as well. I've seen, going back to the equipment or supplies, if you're going to bring your own supplies, you got to have an inventory list to make sure everything is accounted for. And also what you can do with that equipment if you leave the premises. They can buy it or you can take it with you. But it's important to know that, acknowledge that it's your personal property. No exit strategy or termination clause. It's important to have a termination clause, and also how long would you be paid profits if the agreement terminates. I mean, you ramp this business, you get it going, and then you terminate when the business is about to take off. That might not be fair, but that's something that has to be discussed. And what are the reasons for termination? For cost, without cost, what will happen in either case? So that's something that we can, as attorneys, can help you with. Another mistake is ignoring the lease and landlord's restrictions. You as the manager have a responsibility to know everything about that business. And if the owner does not want to disclose that, that's a red flag. Again, the due diligence you're doing here is just the same as if you were going to buy part of that business. financials, contracts, litigation, leases. We go through a whole litigation, a whole due diligence checklist. So it's important for you to know that, because not knowing what the lease agreement is, you're going into a place where you have no idea whether you have the right to enter into place enter in the first place. So you have to have the ability to read that lease. And if the owner says, no, I don't want you to read the lease, I say give that a second thought, because there's no reason why you should not read the lease if you're going to be managing the place and also paying the lease every month. Another mistake that I see is failing to include indemnification clause. You're going to be the face of that business. What happens if you get sued? Who's going to indemnify you? So it's important to have an indemnification clause in that contract that in the case you get sued for something related to the business, not talking anything outside of the business or any type of personal intentional tort, we're not talking about here, or intentional act. We're talking about just customary running the business day to day. You are named a defendant in a lawsuit. Who's going to indemnify you? Are you going to be paying your own legal expenses or somebody else? Are you included in the insurance? These are questions that we ask as well. So I think I went over the real world scenario already, which I was going to do that at the end, but I did at the beginning. But I want to talk about, recap kind of the best practices. If you're looking to have a management agreement or considering, or you were invited to have a management agreement, what are some of the best practices to think of or ask questions about? The first one, of course, hire an attorney. That first and foremost, because that will help you navigate this and will give you greater probabilities of success by having a contract drafted by an attorney rather than a contract that you do on your own or just download from the web. But obviously, have a written agreement. This particular case, verbal agreements are not going to help you. So have it in writing. And it takes time to draft a management agreement well drafted, but it's time well spent and money well spent. Access to the bank accounts, whether or not you have access to the bank accounts, what authorities do you have to write checks or pay expenses? If you're bringing your own equipment or supplies, have an inventory list and a provision in the agreement that says if you leave for any reason, that equipment goes with you because you brought it, or they can buy it. Whatever the case may be, have it in writing. Clarify how you're going to get paid. It's going to be paid, to a W-2 or salary, or if you're going to basically bring your own company with your own staff, which is another scenario. Say you have your own management company that comes in to manage, and I'll give you an example of management properties. There are different companies that come in and manage a property for a landlord. So in that particular case, the company is the one that gets paid, not the individual. And that is fine, but it has to be well drafted in the agreement. Verifying that the lease allows for a third-party manager to run the business. It's important to have landlord's consent in this case. And if the owner does not want to give you a copy of the lease, or doesn't want you to review it, that's a red flag, and that's something you need to ask why, and have an attorney ask why, and give some thought about that. Otherwise, you're going into a premises that you do not know what right you have to enter in the first place. I mentioned it just a few minutes ago, indemnification clause. In the case that you're named in a lawsuit or a claim individually for acts that you did while you were working for the business. So there's a few tips that I want to share with you, but with the caveat that these are not all the terms that should be included in a management agreement. There's simply some tips that I'm sharing with you. The best advice that I can give you is that if you're about to enter into one of these or contemplating into one of these, get an attorney who can help you So that way you have the proper protections, and you have a more likely to succeed in the venture and the management of that business. I think this is good for today. Want to again share with you if you need to reach me. You want to have any questions about any topics that I've covered so far. This is episode 88, so we cover a variety of topics to date. You can reach me at Rich, R-I-C-H, at richsierra.com, is RICHSIERRA.com. If you're interested in learning more about our legal services that we offer, my website is floridasmallbusinesslegalcenter.com. We're in Facebook at FSB Legal. We're on YouTube.com. If you want to see the video of this podcast, we publish it every week as well. And you can see it at youtube.com/at Richard Sierra. We're on Instagram at FSB Legal. If you would like to call us, my number is 866-842-5202. Remember that business SOS, a common legal mistake business owners make and how to avoid them, is available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. If you like the podcast, I'd like to ask you to please follow us. Also, give us a review, hopefully 5 stars, and put a comment there. It helps the algorithms and promote it through other business owners as well that might be interested in this subject matter. We're in Apple Podcasts, we're in Spotify, we're in iHeart, pretty much in all the podcast channels, wherever you should enjoy your shows. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. And remember that my goal is to help you succeed.